All right, we're going to talk about legal tender today. All right, and there's a lot of people out there sharing some information. I'm particularly watching a certain man who has called me. We've had a pleasant conversation, um, and he is doing some things with 1099s at this point, and I'm pretty intrigued. In fact, he most recently posted some information with a negative accounting. And while most people have a presumption and assumption that the negative accounting is actually bad, from my due diligence and from some of the things some of my constituents have showed me, it is actually a good thing. Uh, uh, a positive number is not good. It's 180 degrees the opposite. So when he shared his results from one of the experiments he was doing from educating himself, and it reflected a deposit of negative 500 into the account, I was actually pretty intrigued by that. And don't let that little minus sign throw you off. That's a positive accounting there on his side of the ledger, from what I have read and from what I have seen and what other people have exhibited to me, doing different processes with, say, the electric company, phone bills, gas bills, so on, so forth. I've seen evidence that when certain processes are executed, they actually send you a statement of a negative accounting. So keep going, buddy. I'm watching. I'm paying attention. I haven't jumped on board your bandwagon yet. I'm just kind of kicking back and watching. I have read through some of the documents you have sent me, and they look really fucking nice. So anyway, affidavit of truth and payment, letter of credit. This is a letter of credit. As you know, there are many ways of tendering a payment. There's the international bill of exchange, the bill of exchange, a promissory note, the letter of credit. Okay. This happens to pertain to a letter of credit. April 20th, 2020, bank name, chief financial officer, Mr. First Last Name, 888 Shyster Bank Street, P.O. Box 000-000. Now, in this instance, I would never use a P.O. box. Do your best to find their headquarters, their main office, and make sure that you're writing it to the chief financial officer, all right? And if you want to supersede the chief financial officer, you just go ahead and send it to the legal department for the institution that you wish to negotiate this instrument with, all right? Because the lawyering craft actually understand this stuff, whereas the chief financial officer, he may not be privy to this information. And if you know anything about these organizations, they take their directives from lawyers. So if you send something to a CEO or CFO, chances are they'll ignore it, they'll blow you off. But if you send it to the legal department will tell the chief financial officer what he is to do, and he will listen to them, or he will bear the liability for failing to do so, right? So these are little tricks I've learned along the way, because I used to tell everybody, just write the CEO and CFO. Write the legal department, all right? And the legal department will give the orders and directives. And then the CEO and CFO will do what they tell them to do, all right? Dear CFO, name representing bank name. These are the banking instrument instructions and letter of credit. Should there be any question, please have your attorneys handle this matter as they are legally competent, all right, to handle a negotiable instrument and under their workings. Ignorance of the law is no excuse to misprocess this note. This note is a secured, transferable, negotiable instrument meeting all requirements of the UCC Article 3 as a money order. Please stamp the note, the certified true copy of the note, and the 2 copies of the letter as post-received, with and on the date received. Please deposit the original note funds in the specified account. Then send the certified true copy of the note and 1 copy of this letter to me via the address below. If necessary, please stamp the private bond with your bank medallion signature guarantee to ensure its proper acceptance for honor and or dishonor. All objections to this payment must be raised within 3 business days of receiving these documents. This note and this self-referencing instruction letter, by new legal action indicating why this note is not acceptable for payment. Should this note be dishonored and or not be honored effective on the 4th business day upon signing for this delivery, this letter is further presentment, we're presenting a present here, and serving as notice of dishonor in accordance with UCC Article 3, subsection 3-503, notice of dishonor. Accept and return for chargeback, set off, discharge, settlement, and closure of this account. You are using my exemption. Send the voucher to the address below in green immediately. Equality under the law is paramount and mandatory by law. I am competent to handle my affairs. If you believe you are representing me in this matter, you and your heirs, assigns agents, are hereby declared to be incompetent and fired, without prejudice, without recourse. Instructions to tender payment. Notice to agent is notice to principal. Notice to principal is notice to agent. Silence is acquiescence, agreement, and dishonor. Notice, this document is not intended to threaten, harass, hinder, or obstruct any lawful operations. It is for the purposes of obtaining lawful and legal remedy, as is provided by law, and tendered with honorable intent. Enclosed, fine promissory note number made out to the bank name to discharge the above referenced account for settlement and closure. This attached negotiable instrument is presented under the authority of the House Joint Resolution 192, Public Law 7310, UCC 3-104C, Spencer v. Sterling Bank, 63 California Appellate Court, 4th, 1055 in 1998, Guntree Trust Co. of New York versus Henwood et al., 307 U.S. 247, FN 3. The within negotiable instrument, Volume 3, including 2006 supplement, on the undersigned's UCC contract trust account, the entire taxing and monetary system are hereby placed under the UCC Uniform Commercial Code, the Federal Tax Lien Act of 1966. Please send receipt for discharging to the address below in care of my notary public attesting witness within 3 days of deposit. As everyone should know, lawful money was removed from our economy by Congress in 1933 by House Joint Resolution 192, and it was actually the Federal Reserve Banking Act of 1933. The House Joint Resolution 192 was the remedy, and replaced with negotiable instruments. These negotiable instruments are considered as legal tender on the same par and category as Federal Reserve notes. They represent a mortgage on all the homes and personal property of all the American people. This mortgage was placed without proper legal authorization by the Congress, and the Supreme Court required that a remedy had to be given to the American people who were principals and sureties for the national debt. This remedy is to discharge debt for the people who demand it. We, the people, were made private bankers according to the law with the authority to issue notes to discharge lawful debts. This must remain in effect until lawful money and the property is returned to we, the people, without any encumbrances. House Joint Resolution 192, which has been repealed, now therefore be it resolved by the Senate and the House of Representatives of the United States of America and Congress assembled that A, every provision contained in or made with respect to any obligation which purports to give the obligee a right to require payment in gold or a particular kind of coin or currency or in an amount in money of the United States measured thereby is declared to be against public policy, and no such provisions shall be contained in or made with respect to any obligations hereinafter incurred. Every obligation heretofore or hereafter incurred, whether or not any such provision is contained therein or made with respect thereto, shall be discharged upon payment, dollar for dollar, in any coin or currency which at the time of payment is legal tender for public and private debts. Legal tender defined. The primary basis for counterclaims is that all commercial instruments such as promissory notes, credit agreements, bills of exchange, and checks are defined as legal tender, or money, by the statutes such as Title 12 U.S.C. 1813 I-1, UCC subsection 1-20124, subsection 3-104, subsection 8-102-9, and subsection 9-102-9, 11, 12b, 49, and 64. Legal tender under the Uniform Commercial Code, UCC, section 1-20124, official comment. The referenced official comment notes that the definition of money is not limited to legal tender under the UCC. The test adopted is that of sanction of government, whether by authorization before issue or adoption afterwards, which recognize the circulating medium as a part of the official currency of that government. The narrow view that money is limited to legal tender is rejected. In light of the holding of Guarantee Trust Company versus Henwood, 307 U.S. 247 in 1939, a federal U.S. Court of Appeals ruled on Title 31 U.S.C. 5118 as of October 27, 1977, legal tender for discharge of debt is no longer required. That is because legal tender is not in circulation at par with promise to pay credit. Requirement of repayment of debt is against public policy. Since legal tender was not loaned nor in circulation, they cannot demand payment in any particular form of coin or currency or legal tender, and repayment or payment need only be made in equivalent kind, a negotiable instrument. House Joint Resolution 192, Public Law 7310, and Title 31 U.S.C. 5118 prohibits banks, creditors, from demanding any specific specie of payment. All banks must process lawful United States currency. Failure to do so is interference with commerce. A violation of Title 15, subsection 1, subpart 1 comes at a $100 million fine. A felony under the RICO Act, Title 18, U.S.C. 1951. If you believe you have a lawful reason to dishonor this negotiable instrument, you must return it to the agent above with lawful reason or reasons fully stated and cited, sworn under your unlimited liability both commercially and personally. Failure to provide your lawful reason or reasons or to misdirect this instrument is grounds for a complaint to the FTC, Federal Trade Commission, under the FDCPA, Fair Debt Collection Practices Act, Title 15 U.S.C. 1692A1. It is your duty to honor this instrument for payment, to know, abide by, and operate under the law. Title 18 U.S.C. subsection 8 applies, which means that all debt obligations, notes, bills of exchange, checks, drafts are all obligations of the United States. Commercial instruments are legal tender for payment of debt in accordance with Title 31 U.S.C. 5118 and other statutes, codes. Failure to process and credit the intended account will result in a request of the Postal Inspector Office, the OIG, Inspector General for the Post Office, to investigate and audit the account balance sheet, optional, and file IRS Form 3949A information referral to the CID, Criminal Investigation Division of the IRS. The UCC, Uniform Commercial Code, defines a negotiable instrument as an unconditioned writing that promises or orders the payment of a fixed amount of money. To be considered negotiable, an instrument must meet the requirements stated in Article 3. UCC Article 3, Negotiable Instruments, subsection 3-104, Negotiable Instruments. A negotiable instrument means an unconditional promise or order to pay a fixed amount of money. B. Instrument means a negotiable instrument. FRN's Federal Reserve notes are worthless. The Federal Reserve Bank, in its booklet, Modern Money Mechanics, page 3, states, in the United States, neither paper currency nor deposits have as commodities. Intrinsically, a dollar bill is just a piece of paper. Deposits merely book entries. The giving a Federal Reserve note does not constitute payment. See Eckhart versus Commissioners, CCA 42 FD 2D 158. The use of a Federal Reserve note is only a promise to pay. See Fidelity Savings versus Grimes, 131 P2D 894. Legal tender Federal Reserve notes are not good and lawful money of the United States. See Raines versus State, 226 S.W. 189. That Federal Reserve notes do not operate as payment in the absence of an agreement that they shall constitute payment. See Blanchere, MFG, that's BLACHSHEAR, MFG Co. Versus Harrell, HARRELL, 2S.E.2D 766. Federal Reserve notes are valueless. See IRS Code Section 1.1001-1, 4657 C.C.H. Rejection. California Commercial Code 3603, UCC 3-603, if tender of payment of an obligation to pay an instrument is made to a person entitled to enforce the instrument and the tender is refused, there is discharge to the extent of the amount of the tender. Failure to accept this note for deposit and discharge of this debt is lawfully considered theft, fraud, conspiracy, conclusion, racketeering, and denial of due process of law. I believe there is no evidence to the contrary. Otherwise, provided lawful proof of claim by representing to me lawful document or documents that show that you have the lawful authority to dishonor my note. Failure to provide lawfully documented evidence that is certified lawful, true, and correct, verified by notarized affidavit that is signed under the penalties of the law, including perjury, will be default. Failure to honor this legal tender requires you to surrender all public hazard bonds, corporate bonds, blanket bonds, insurance policies, CAFR funds, 401ks, 801ks, retirement funds, personal wealth and properties, or any other source of revenue as needed to cure your dishonor in commerce and submit to the authorities for criminal prosecution. Evidence of a debt are not money and are not legal tender. Checks, credit cards, lines of credit, demand deposit, credit, letters of credit, and checkbook money. Howard and Foster Co. versus Citizen National Bank of the Union, 33 S.C. 202 130 S.E. 758. Norton Grocery Co. versus People's National Bank, 144 S.E. 501 151 VA 195. Checks, drafts, money orders, and banknotes are not lawful money of the United States. State versus Neilon, Neilon, 73 Pac. 3211, 43 Oregon 168. A national bank cannot lend its credit to another by becoming surety, endorser, or grantor for him, such an act being ultra-virus. Merchants Bank versus Baird, B-A-I-R-D, 160 F. 642. Revised Statute of the United States, First Session, 43rd Congress, 1873 through 1874, Title LXX, Crimes, Chapter 4, Crimes Against Justice, Section 5407, Conspiracy to Defeat Enforcement of the Laws. If two or more persons in any state or territory conspire for the purposes of impeding, hindering, obstructing, or defeating in any manner the due course of justice in any state or territory with intent to deny to any citizen the equal protection of the laws or to injure him or his property for lawful of any person or class of persons to the equal protection of the laws, each of such persons shall be punished by a fine of not less than $500 nor more than $5,000, or by imprisonment, with or without hard labor, not less than 6 months nor more than 6 years, or by both such fine and imprisonment. See subsection 1977 through 1991, 2004 through 2010, 5506 through 5510.1. All rights reserved, UCC 1-308. By name here, authorized representative, UCC-3-402, void if prohibited by law. That is such a poignant statement to make. Void where prohibited by law it's an insurance clause, essentially. Public policy or statute. Acknowledgement of notary for verification purposes only. On the day of 2000, before me, a notary public personally appeared, your name personally known to me or proved to me on the basis of satisfactory evidence of identification to be a person whose name is subscribed to the within instrument or instruments and acknowledged to me that he executed the same in his authorized capacity and that by his signature on the instrument, the person or the entity upon behalf of which the person acted executed that instrument. Oh yeah, these are pretty instruments. Yeah. Alrighty. Now, let's go back here because we got more good stuff. Bam. Let's go to this one. Shoo-ba-doo-ba-doo. There we go. All right. Bear with me, folks, if you will. Now, we're going to go into what would happen if they happen by chance to dishonor your instrument. Now, there's a couple things that I want to point out here. This is from a number of different people who have helped me comprehend international bills of exchange, letters of credit. Title 12, 95A, which was repealed, has been formally moved to Title 50, 4305B2. Now, when you read Title 50, 4305B2, it's very evident, self-evident, okay? One, Title 12 is the banking code. Title 50 is the military code. So the whole banking thing has been shifted over to the military control, okay? And it says in Title 50, 4305B2 that anything done or omitted in good faith is not a jailable offense. So it may behoove you to put done in good faith, with good conscience, for good reason, for good purpose, all right? It may also behoove you to, above your signature, put given for a patent right on an instrument. If you have the kind of knowledge and the balls to pull this off, okay, which shouldn't be a scary thing once you become learned. It's really not a scary thing, because what's the worst they can tell you? No. Are they going to try and bring charges against you for fraud? No, they're not. No, they're not, because they already have the law presented to them where they have to accept and acknowledge the documents, okay? So if they try to bring charges against you for fraud or conspiracy to defraud them, that'll be rather entertaining, okay? Because they have the onus of probandi to prove that somehow you've tried to fraud them when you've given them the law, all right? Dear Mr. Doe, I am writing regarding your recent letter in regards to your client XYZ Corp. Being the alleged creditor in the amount of $1,100, your alleged client has waived their status as a creditor when they accepted my tender of payment under UCC 3-409A and B and UCC subsection 3-604A. Now, you have to ask yourself, why is the UCC so important when you're dealing with the banks, okay, or any institution that is dealing with the banking sector? Because the UCC deals with negotiable instruments, creditors, bonds, IBOEs, bills of exchange, checks, drafts, all that good shit, okay? It's all in the UCC, which is for the banking aspect of everything. And that is, in fact, what your military courts, your Article 1, subsection 8, Clause 3, Clause 17, Clause 14, whatever you want to look at them as, your military venues are actually doing. They're engaged in banking, okay? And that is why the UCC is so prevalent in the courtroom if you know how to use it, okay? So, we'll continue on. They did not adjust their accounting ledger to reflect settlement and closure of the accounts receivable side of the accounting ledger. By way of review, I sent the woman in the credit department of the creditor a negotiable instrument on April 24th in the form of a commercial note draft as an order to pay under UCC 3-104E. This may be treated either as a promise to pay or an order to pay. Since she has not returned the instrument to me, she has obviously chosen the latter, an order to pay. Under subsection 3-104F of the UCC, a draft is the equivalent of a check and may be securitized or monetized by direct deposit in a commercial checking, time, thrift, or savings account under Title 12 of the United States Code. Section 1813 L1. Now, remember, I told you Title 12 is the banking code, right? Title 12 is where you'll find all the banking codes. UCC is the grounds or the foundation for negotiable instruments and dishonor and honor and so on and so forth. That all pertains to banking, okay? Section 1813 L1, and when deposited, it becomes the equivalent of money as outlined under Section 1813 L1. The collection manager for the credit department of the creditor did, however, send me a letter saying that she did not accept promissory notes. She is, however, precluded by public policy, House Joint Resolution 192, Title 31 of the United States Code, Section 5118 D2, and the Fair Debt Collection Practices Act, aka Consumer Protection Act, at Title 15 USC subsection 1601 and subsection 1693 from demanding payment in any specie, coin, or currency of the United States. Even though she has not done so, Section D2 of Title 31 USC subsection 1518 states that an obligation governed by gold coin is discharged on payment dollar for dollar by United States coin or currency that is a legal tender at the time of payment. The narrow view that money is limited to legal tender is rejected under Section 1-201-24 of the UCC. It is not limited to the United States dollar. See official comments under Sections 3-104 of the UCC under the definitions of money. The woman at the creditor has failed to perform her duty as fiduciary trustee of the account. I have done a national protest against her and the account for non-acceptance and payment under Sections 3-501 of the UCC and 3-505AB of the UCC, which creates the evidence or presumption of a dishonor. She is knowingly or unknowingly becoming the debtor and myself the creditor by operation of commercial and administrative law. Also worthy of a note, if she is going to treat the note as a liability instrument, she has to present it to me for payment, make me chargeable under UCC 3-501 of the UCC, which she has also failed to do. To the extent that she is in dishonor for non-acceptance and non-payment by notarial protest on the administrative side, there has been a discharge of the debt in its entirety under the Fair Debt Collection Practices Act within the 30-day time frame as mandated by law. Since I am reasonably sure that we can come to a peaceful resolution of this matter, as your client does not understand commercial banking law and the IASB and the FASB and the GAAP principles as they apply to commercial banking, I do a lot of trading and purchasing in the commodities and securities exchange market where the use of a revocable standby letter of credit, documentary drafts, international bills of exchange, or promissory notes are used exclusively under the Unicitral Convention, UNICITRAL. All right. UNICITRAL Convention. I think that actually stands for the, I'll get back to that later. Your client is not applying the correct accounting entries under GAAP. She is treating the account as a trade receivable through securitization as an off-balance sheet financing technique. Since she has accepted the instrument that I have tendered, I have a claim or possessionary right in the instrument and its proceeds under UCC 3-306 of the UCC. Any defense and any claim in recoupment under Section 3-305 of the UCC, which I shall exercise at my option. If she does not credit my account, the 1099 OID will identify who the principal is from, which capital and interest were taken, and who the recipient or who the payer of the funds are, and who is holding the account in escrow and unadjusted. Since I am a solution-oriented and want to show good faith, there are two ways of resolving this matter. Since your client has already accepted my tender of payment and has not returned it, you can instruct her to credit my account for the sum said in full for settlement and closure, or instruct her to return the original instrument to me, unendorsed, and I will make an alternative form of payment. Otherwise, I will consider this matter settled and closed. Nice little dispute letter there. What else do we got in our little bag of tricks over here? We got all kinds of good stuff. They used to have maybe some maxims on money. Let's see what we got for maxims. Where's my money maxims at? I used to have a whole litany of them. Oh, let's do this. Maybe it's money cheat sheet. Money cheat sheet. Money cheat sheet. Let's see what comes up. Equity maxims evolve. I found that. Yep, there it is. By golly, by golly. Wonderful. Money cheat sheet is straight out of their codes about 6 years ago. It's short and it's sweet. We like short and sweet, don't we, people? Oh, what is this going to go into? All right. Again, we have one of my wonderful mentors to thank for this beautiful little cheat sheet on money. This guy spends countless hours dissecting statutes, codes, city ordinances, rules, regulations, common law, canon law, the law of mercantile, just all kinds of off-the-whim, batshit crazy studies this guy does. And he loves to help give me credible information that I can disseminate to you guys that you can put in your little arsenal, your little spank bank for an ammunition pack while you march off to war in the Sea of Commerce, right? Because if you don't know your rights, you don't have any rights. And if you don't understand the rules of the game, how could you ever fucking play? All right? So welcome to the world's biggest game. United States Code Title 31, Money and Finance. This title was enacted by Public Law 97-258, subsection 1, September 13th, 1982, 96 Stat 877. Subtitle General Chapter Definitions, subsection 103, United States. In this title, United States, when used in a geographical sense, means the states. These are U.S. enfranchisements appearing to be de jure states of the United States of the District of Columbia, all right? Title 28, Federal Enclave Territory, Guam, Samoa, the Swaney Islands, Puerto Rico, Washington, D.C., obviously, right? Public Law 97-258, September 13th, 1982, 96 Stat 877. The people of Nebraska Territory applied and qualified to create a state government, authorized on 19th April 1864, ratified their constitution about 6 months before they were allowed to join the Union. Nebraska 1866, Article 2, Schedule Subsection 1 provided wherever the word territory shall occur, it shall be construed to mean state, capital letter state, whenever it may be necessary in order that such laws may conform to the state government. Subsection 302, Treasury of the United States. The United States government has a Treasury of the United States. The Treasury is in the Department of the Treasury. Public Law 97-258, September 13th, 1982, 96 Stat 879. Subtitle 4, Money, Chapter 51, Coins and Currency, Subchapter 1, Monetary System. Subsection 5102, Standard Weight. The standard troy pound of the National Institutes of Standards and Technology of the Department of Commerce shall be the standard used to ensure that the weight of the United States coins conform to specifications in Section 5112 of this title. Public Law 97-258, September 13, 1982, 96 Stat 980, Public Law 100-418, Title 5 and subsection 5115C, August 23, 1988, 102 Stat 1433. Subsection 5103, Legal Tender. United States coins and currency, including Federal Reserve notes and circulating notes of Federal Reserve banks and national banks, are legal tender for all debts, public charges, taxes, and dues. Foreign gold or silver coins are not legal tender for debts. Public Law 97-258, September 13, 1982, 96 Stat 980, Public Law 97-452, subsection 1, parentheses 19, January 12th, 1983, 96 Stat 2477. Subchapter 2, General Authorities. Subsection 5112, Denomination, Specifications, and Design of the Coins. A. The Secretary of the Treasury may mint and issue only the following coins, values based upon commodities price on 31 August of 15. 1. A dollar coin that is 1.043 26.5 millimeters in diameter. Notice they don't indicate any weight. All right, because they're not talking about the real fucking dollar, people. All right, he's pointing this out. A $half coin is 1.205, 30.6 millimeters in diameter and weight, 11.34 grams, 0.37 troy ounces, or 2.84 grams of nickel equals 3 cents, downgraded 16.7 times. 3. A $quarter coin that is 0.955, 24.3 millimeters in diameter and weighs 5.67 grams for a total of 0.18 troy ounces, 1.42 grams of nickel equals 1.6 cents, downgraded 15.6 times. 4. A dime coin that is 0.705, 17.9 millimeters in diameter and weighs 2.268 grams, 0.07 troy ounces, 0.567 grams of nickel equals 7 cents, downgraded 14.3 times. As you can see, my friend James here is quite the meticulous mathematician, showing how they've stunningly, cunningly deceived us all into using frivolous shit that really doesn't have a value. 5. A 5-cent coin that is 0.835, 21.2 millimeters in diameter and weighs 5 grams, 0.16 troy ounces, or 1.25 grams of nickel equals 1.4 cents, downgraded 3.6 times. 6. Except as provided under subsection C of this section, a 1-cent coin that is 0.75, 19.1 millimeters in diameter and weighs 3.11 grams, or 0.1 troy ounce, 0.156 grams of zinc equals 0.03 cents, downgraded 33.3, the magical downgraded 33.3 times its value, that magical Masonic number. 7. A $50 gold coin that is 32.7 millimeters in diameter, weighs 33.931 grams for a total of 1.09 troy ounces and contains 1 troy ounce of fine gold equals $1,128.31, leveraged 22.5 times. Now, this math, again, is from a number of years ago. Okay, so all these figures as far as what it's leveraged at now are way different, because I think gold's up to almost $2,000 an ounce. So these figures change, but the weights of the coins do not. Okay, these are all by troy ounce measurements, all authorized by Congress, in most respects created by George Washington, leaving the metric system. He's the one that came up with the standard weights and measures for the coins, if my recollection serves me correct. 8. A $25 gold coin that is 27.0 millimeters in diameter, weighs 16.966 grams, a total of 0.55 troy ounces, and contains 1/2 troy ounce of fine gold, equals 565.16. Again, these numbers are from previous years. I don't have the exact year that he did these calculations, but you can use the general information and then go look at the common gold standard price today, and you can refigure these calculations. 9. A $10 gold coin that is 22.0 millimeters in diameter, weighs 8.483 grams, 0.27 troy ounces, and contains 1/4 troy ounce of fine gold, equals $282.08. Federal Reserve notes. A fine dollar gold coin that is 16.5 millimeters in diameter, weighs 3.393 grams, 0.11 troy ounces, and contains 1/10 troy ounce of fine gold, is valued at that current time was $112.83 in Federal Reserve fake fiat worthless shit. 11. A fake $50 gold coin that is of an appropriate size and thickness as determined by the Secretary's weighs 1 ounce, equals 0.91146 troy ounces, 28.35 grams, and contains 99.99% pure gold, equals $1,028.46, leveraged 20.6 times. And again, this was years ago when he created this. This could have been clear back in 2016 for all I know. All right. And the reason this is important is because when he gave this to me, what I was doing in the court was I was agreeing to pay if they could just tell me how much a dollar weighed. And you ought to have seen their face. What was the question again? How much does a fucking dollar weigh, dude? I'm willing to give you a fucking dollar. Just tell me how much it weighs, and I will go get you a fucking dollar. And they have no idea about weights and measures. And if they do know about weights and measures, they damn sure ain't gonna fucking tell you in court how much a real dollar weighs, okay? So, 12, a fake $25 coin of an appropriate size and thickness as determined by the Secretary that weighs 1 troy ounce, 31.1 gram, and contains 0.9995 fine palladium, equals $586.20, leveraged 23.5 times. He's a little bit of a stickler for math. He even breaks down gas prices to how much it's inflated compared to the gold standard and everything else. B, the $50, $quarter, and dime coins are clad coins with 3 layers of metal. The 2 identical outer layers are an alloy of 75% copper and 25% nickel. The inner layer is copper. He's a metallurgist. I can't say it. Metallurgist. He works with metals. The outer layers are metallurgically bonded to the inner layer and weight at least 30% of the weight of the coin. The 5-cent coin is an alloy of 75% copper and 25% nickel. In minting 5-cent coins, the Secretary shall use bars that vary not more than 2.5% from the percent of nickel required, except as provided under subsection C of this section. The 1-cent coin is an alloy of 95% copper and 5% zinc. The rest of this section defines the coin offered each year as whatever, usually mint proof. E, notwithstanding any of the provisions of the law, the Secretary shall mint and issue in qualities and quantities that the Secretary determines are sufficient to meet public demand coins which are total bullshit and not really money, as the commodities market price are very flexible. 1, are 40.6 millimeters, 1.6 inches in diameter, and weigh 31.103 grams, 1 troy ounce, worth about 15 Federal Reserve notes as compared above. 2. Contained .999 fine silver. And 3. Have a design. A symbolic of liberty on the obverse side, and B, of an eagle on the reverse side. 4. Have inscriptions of the year of minting or issuance and the words liberty, in God we trust, United States of America, 1 ounce fine silver, e pluribus unum, and $1. And 5. Have reeded edges. F. Silver coins. Numismatic items. For purposes of Section 5132A1 of this title, all coins minted under subsection E shall be considered to be numismatic items. G. For purposes of Section 5132A1 of this title, all coins minted under subsection E of this section shall be considered numismatic items. H. The coin issued under this title shall be legal tender as provided in subsection 5103 of this title. I1, notwithstanding section 5111A1 of this title, the Secretary shall mint and issue the gold coins described in paragraph 7, 8, 9, and 10 of subsection A of this section in qualities and quantities that the Secretary determines are sufficient to meet public demand, and such gold coins shall, A, have a design determined by the Secretary, except that the $50 gold coin shall have, I, an obverse side, a design symbolic of liberty, and 2, the reverse side, a design representing a family of eagles, with the male carrying an olive branch and flying above a nest containing a female eagle and hatchlings. B, having inscriptions of the denomination, the weight of the fine gold content, the year of the minting or issuance, and the words liberty, in God we trust, United States of America, and e pluribus unum. And C, have reeded edges. 3, for the purposes of Section 5132A1 of this title, all coins minted under this subsection shall be considered to be numismatic items. K. The Secretary may mint and issue platinum bullion coins and proof platinum coins in accordance with such specifications, designed, verities, quantities, denominations, and inscriptions as the Secretary, in the Secretary's discretion, may prescribe from time to time. And this is all supported by a whole gobbledygook of public laws and Senate and all that. And I'm not going to read them all because there are, just by guessing, probably 50 to 60 of them here. And I'm not going to go through them all. Subsection 5115, United States currency note. The Secretary of the Treasury may issue United States currency notes. The notes, 1, are payable to bearer, and 2, shall be in the form of the denomination of at least $1 that the Secretary prescribes. B, the amount of the United States currency notes outstanding and in circulation, 1, may not be more than 300 million, and 2, may not be held or used for a reserve. Public Law 9720, 258, September 13th, 1982, 96 Stat 983. Subsection 5118, gold clause and consent to sue. A. In this section, gold clause means a provision in or related to an obligation alleging to give the obligee a right to require payment in A, gold, B, a particular United States coin or currency, or C, United States money measured in gold or a particular United States coin or currency. B, the United States government may not pay out any gold coin. C1. The government withdraws its consent given to any to assert against the government, its agencies, or its officers, employees, or agents a claim, A, on a gold clause, public debt obligation, or interest on that obligation. On the obligation. B, for the United States coins or currency, or C, arising out of the surrender, requisition, seizure, or acquisition of the United States coins or currency, gold or silver, involving the effect or validity of a change in the metallic content of the dollar or in regulation above the value of money. 2, paragraph 1. of this subsection does not apply to proceedings in which no claim is made for payment or credit in an amount greater than the face or nominal value in dollars of public debt obligations of the United States coins or currencies involved in the proceedings. 3. Except when consent is not withdrawn under this subsection, an amount appropriate for payment on the public debt obligations of the United States coins and currency may be expended only dollar for dollar. D1 in the section, obligation means any obligation except United States currency payable in United States money. 2. An obligation issued containing a gold clause or governed by a gold clause is discharged on payment dollar for dollar in the United States coin or currency that is legal tender at the time of payment. This paragraph does not apply to an obligation issued after October 27, 1977. This is supported by Public Law 97-258, September 13, 1982, 96 Stat 985, Public Law 99-185, subsection 2D, December 17, 1985, 99 Stat 1178, Public Law 104-208, DIV A Title 2, subsection 2609, and September 30th, 1996, and 110 Stat 3009-475, Public Law 105-61, Title 6, subsection 641, October 10th, 1997, and now 111 Stat 1318. Whew. I should become an auctioneer. I think I'd be a damn good auctioneer. Sold into bondage, right? You know, I could be an auctioneer at a courthouse. Who give me 5, 5, 5, 10, 10, 10, 10, 10, 10, 10. Sold! Sold that sumbitch to a cage. Subsection 5119, redemption and cancellation of currency. A, except to the extent authorized in regulations, the Secretary of the Treasury prescribed with the approval of the President, the Secretary may not redeem United States currency, including Federal Reserve notes and circulating notes of Federal Reserve banks and national banks in gold. Public Law 97-258, September 13th, 1982, 96 Stat 8985, Public Law 102-390, Title 2, subsection 226B, October 6th, 1992, 106 Stat 1630, Public Law 103-325, and Title 6, subsection 602G14, September 23rd, 1994, and 108 Stat 2294. The only reason I'm reading all those to you is because he put his little sweat, heart, and tears into doing all the research and putting this shit together for you. And I made a mistake up above when I was reading the diameters in millimeters, and then it was the circumference in inches, not troy ounces of weight. So forgive me for that. I just caught that mistake as I was going along here. Anyway, continuing on. Subsection 5154, state taxation. A state or a territory or possession of the United States may tax United States coins and currency, including Federal Reserve notes and circulating notes of Federal Reserve banks and national banks as money on hand or on deposit in the same way that the same rate that the state, territory, or possession tax other forms of money. This section does not affect the law taxing national banks. Public Law 97-258, September 13th, 1982, 96 Stat 992, Public Law 97-452, subsection 122, January 12, 1983, 96 Stat 2477. However, I have a United States Supreme Court case that says otherwise. They cannot tax anything other than gold, or they cannot require a payment for taxes in anything other than gold and silver. And I have a United States Supreme Court case that, near as I can tell, has never been overturned, still stands the test of time, and they cannot demand anything other than gold and silver for a payment of taxes. Anderson's Dictionary, 1989, Law Dictionary, page 372, dollar, the unit of our currency, money, or its equivalent, a silver coin weighing 412 1/2 grains, or a gold coin weighing 25 4/5 grains of 9/10 pure to 1/10 alloy of each metal. The coined dollar of the United States has certain quantity and fineness of gold or silver, authenticated as such by the stamp of the government. Remember, they were charged with the duty of weights and measures, right? They were charged with the duty of making sure nobody was tampering with our money, because gold and silver is money. That's dollar. It stood the test of time from the beginning of time. Remember, in the Bible, God said gold and silver are good. A lot of people don't realize this, but gold is mentioned in the Bible over 800 times. Go look it up. Pretty impressive. Carrying on, IBID, page 191, coin. A piece of metal stamped and made legally current as money, coin, and coinage apply to the stamping of metal in some way so as to give them currency. The gold coin of the United States shall be $1 piece, with, at the standard weight of 25 and 8/10 grains, shall be the unit of value. A quarter eagle, where we go, or a quarter eagle or $2.50 pieces, a $3 piece, a Holt, I think that's supposed to be a half eagle. It says Holt. I'll just say Holt eagle. I think it's supposed to be a half eagle, a $5 piece, and an eagle or $10 piece, and a double eagle or a $20 piece. The silver coin shall be a trade dollar, a $half or 50-cent piece, a $quarter or 25-cent piece, a dime or 10-cent piece. The weight of the trade dollar shall be 420 grains troy. The weight of the $half, 12 grams and 1/2 of a gram. The $quarter and the dime, respectively, 1/2 and 1/5 of the weight of the said $half. The standard of both gold and silver coins shall be such that the 1,000 parts by weight, 9/100 shall be pure metal and 100 of alloy. The alloy of the silver coin shall be copper. The alloy of the gold coin shall be of copper, or of copper and silver, but the silver shall in no case exceed 1/10 of the whole alloy. The minor coin shall be a 5-cent piece, a 3-cent piece, and a 1-cent piece, and their weight, respectively, 77 and 16/100 grains troy, 30 grains and 48 grains. The alloy of the 5 and 3-cent piece shall be a copper and nickel 3/4 to 1/4. The alloy of the 1-cent piece, 95% of copper and 5% of tin and zinc. There shall be coined silver dollars of the weight of 412.5 grains troy of standard silver, as provided in the Act of January 18th, 1837, 5 St. L. 137. The United States Constitution, Article 1, Section 10, Clause 1, no state shall coin money or make anything but gold and silver coin a tender in payment of the debt. Compare this to 5103 above, which indicates the opposite. What are you using for commercial exchange? How does that affect your legal status or remedies? Remember, title only passes through hand through value and consideration, and valuable consideration. Title deeds, warranty deeds, grant deeds, they only shift from one to the other through gold and silver, period. That's been a long-standing tradition and way of law. So keep that in mind. That never happens when you're doing your warranty deed, joint tenancy deed, grant deeds, any of that stuff. What else can we find in here? Let's see what other cheat sheets we have here. I love his cheat sheets on money because they're fucking hilarious. We use them in court all the time. Recording papers cheat sheet. That deals with the clerk of the court. I am sharing 732244490. Tort case cheat sheet. Nobody wants to hear that shit, buddy. I found the money cheat sheet. Equity maximums. Mental health. Fuck it. Let's see what he's got on this cheat sheet. We love our brother James. Always just meticulously working away, creating all kinds of cheat sheets. Oh, you guys all like this one. Maybe. Let's see. Here we go. Cheat sheet. Check this out. I will be with you in a second, brother. I got a guy that highly educated from Yale University I've been in contact with lately, and we are having an abundance of fun pointing shit out to one another and learning and exchanging information. It's very pertinent that everybody keep their mind open, their eyes open, their ears open. Don't think that you know everything, because then you limit your capacity to gain even more knowledge. Be a sponge, absorb it all. This gentleman is highly educated, highly articulate. It's hard for me to keep up with him at times. And we're sharing intellectual information that neither one of us really, like, I'm not a big statute, code, city ordinance, rule, regulation type of guy, and he's over here showing me, hey, check this out. If you do, take your applied knowledge that you already have and you use this shit right here, and then I show you how to go in and find the unpublished case findings and rulings, dude, you're going to be a nightmare. You're going to be an absolute monster. And at the same token, I'm going, hey, look at all this shit that I use that works, buddy. And he's like, oh man, this is a plethora of information. This is a gold mine here. And if I combine this with proper process and procedure, buddy, check out how fucking absolutely badass we can be. And so it's been a lot of fun over the last couple days. Battery, DF, 1, acted, 2, intending, 2, TO, 3, cause a harmful or offensive touching of the PL, the people, battery. Okay, so battery is acted, intending, causes a harmful or offensive touching of the people. That's a battery. Assault is acted, intending to cause a reasonable apprehension of a battery on the part of the people or public. I'm not sure what he's doing with the PL and the plaintiff. Okay, I see what he's doing. He's got defendant, plaintiff. I got it. Gotcha, brother. False imprisonment. Defendant acted intending to cause the plaintiff to be knowingly confined to a bounded area. Trespass to land. These are torts. Tort claims is what he's structuring here, showing you how you would articulate that in his mind, through his research, through his studies. Simple, short, concise, and to the point. Okay, so we covered false imprisonment. Trespass to land. Intentional act by defendant causing a physical invasion of plaintiff's land. Trespass to chattels. Now, this is a good one because children are not what you think they are. They're dealing with chattels. That's chattel papers. That's chattel. They're not dealing with offspring. They're dealing with chattel. Trespass to chattels. Intentional acts by defendant causing a temporary or minor interference or damage to plaintiff's chattels. Conversion. Intentional act by defendant causing a serious interference with plaintiff's possessory interest in chattels. Intentional infliction of emotional distress. Defendant acted with extreme and outrageous conduct with intent or recklessness to cause severe emotional distress on the part of the plaintiff. Outrageous transcends bounds of decency, reckless in disregard of high probability of distress. Defense, consent, express implied in law, must be able to consent and within scope of consent. Defense of self or others requires a reasonable belief of an attack and limited to reasonably necessary force to prevent the harm. Also, defense of injuries to bystanders. Defense of property requires an initial request to desist unless dangerous or futile, and only to prevent a tort. Hot pursuit also supersedes by necessity recapture of chattels, mistake allowed except regarding privilege. Recapture of chattels requires timely demand unless danger or futile, hot pursuit, and only from wrongdoer. Trespass for recovery of chattels requires prior demand within reasonable time and reasonable manner on wrongdoer's property. Necessity requires an act for the benefit of any person or to protect any property from destruction or serious injury, but 3 requires actors to pay for damages caused. Shopkeeper's privilege requires that suspicion be reasonable as well as the nature and the duration of confinement. Negligence requires that the defendant breach a duty to the plaintiff actually and proximately causing damages. Res ipsa, ipsa, RESIPSA, requires showing that actions generally does not happen without negligence. defendant was in exclusive control of the dangerous instrumentality and no contributory negligence. Some jurisdiction added, he abbreviates shit and I gotta figure it out, show more likely than not that was the cause, gets you negligence per se, rebuttal negligence, or evidence of negligence depending on jurisdiction. Defense, contributory comparative, last clear chance in contributory, assumption of risk, express everywhere, implied only in contributory. Products liability requires defendants, commercial supplier, products left in the condition, product was defective, and defect caused damage. Manufacturer's defect required that products differed from design. Design defect requires that 402-A product was more dangerous than ordinary consumer would expect, or 23D REST, a safer alternative design is available that would not compromise market feasibility to product utility. Defective for lack of adequate warning requires that the product 402A had hidden danger or was more dangerous than an ordinary consumer would expect, or 23D REST had dangers information about which would materially alter ordinary consumer decisions to purchase or use. Defense misuse, open and observed, state-of-the-art, learned intermediary, implied warranty, and merchantability and fitness. When a merchant is a dealer is type of goods, the UCC stipulates that there is an implied warranty of merchantability and general fitness. Plaintiffs for injury are either purchasers, family, guests, or natural persons with injuries, or everyone can also get purely economic damages. Negligent infliction of emotional distress. Dillon rule on zone of danger. People on property. Undiscovered trespasser. A. No duty owed, no standard of care. 2. Any other kind of plaintiff must ask what caused the injury. A. Activity. Anything owner occupied is doing on the land. Anything owner occupier is doing on the land. 1. Ordinary negligence case. 2. Reasonable person standard. And 3. Plaintiff distinction does not matter. B. Dangerous conditions. Anything about the land, ergo a whole. 1. Plaintiff's distinction is relevant. 3. Discovered by trespasser. A. Responsible for 1. Artificial conditions, person put it there. 2. Involving risk or serious injury, not lesser injuries. 3. That the owner occupier knows of. And 4. License, person there for their own purpose, social guest. 2. Responsible for warn of dangerous conditions. 2. The owner occupier knows in fact. Invitee, person there for purposes of owner occupier response. B. The owner occupier is responsible. 1. Dangerous conditions, all dangerous conditions. 2. The owner occupier should know about. And 3. Duty to make reasonable inspection of property for benefit of invitees. Sorry, I didn't mean to bore you with that one. But cheat sheets, gotta love them cheat sheets. Cheat sheets about your county clerks. Now, a lot of this is going to pertain to Nebraska. Sorry about that, but this should give you a little insight and hope that you can too find this in your states, codes, and everything else. Because if it's in Nebraska, typically it's going to be everywhere else. You just have to go find it. It may not be verbatim, but it will be similar, all right? Documents recorded and record keepers, okay? 11-101, oath of office. Officers of the state and political subdivisions, except constitutional officers, form endorsement on bonds filing. All states, district, county, precinct, township, municipal, and especially appointed officers, except those mentioned in Article 15, Section 1 of the Constitution for the State of Nebraska, shall before entering upon their respective duties take and subscribe the following oath, which shall be endorsed upon their respective bond. I, blank, do so help me God. If any such officer is not required to give bond, the oath shall be filed in the office of the Secretary of State or of the clerk of the county, city, village, or other municipal subdivision of which he shall be an officer. Okay, so in your state, per se, you may look at the Secretary of State's office for the judge's oath of office. They may even have their bonds. Highly unlikely they have their bonds, so check with the clerk of the county to see if their bonds and their oaths of office are recorded in the county or area they're working in. Check with the city, the village, or the municipal subdivisions of which he shall be an officer, okay? Just a little insight, all right? 49-801, statutes, terms defined unless the context is shown to intend otherwise. Words and phrases in the statutes of Nebraska hereafter enacted are used in the following senses. 3. Attorney shall mean attorney at law. Boy, we're going to have to write the legislator and tell them they forgot a couple parts of that. 10. Inhabitant shall be construed to mean a resident in a particular locality in reference to which that word is used. Now, this is kind of funny. Inhabitant shall be construed. It's not, I mean, it's so vague and ambiguously written. Shall be construed. Well, wait a minute here. He either is an inhabitant or he's not. He either is a resident or he's not. You still play by their rules, you will lose. Make them play by your rules under Article 3 Court. Article 3 Court, I agree with you, buddy. Just here giving a little bit of insight, pointing some shit out. That's all we're doing. Not trying to distract anybody, not trying to confuse anybody, just trying to show people from where one's reason and logic and understanding stems from. For example, I'm pointing out right now, the statute, code, city ordinance, rules, and regulations, they are vague and ambiguous, okay? That there is no clear-cut definition for many of these words, and they use things like shall, which doesn't mean must. Shall means may or may not sometime in the future, and Justice Scalia, before his untimely death, even put that in a conclusion. In the Gonzalez case in Colorado, where the woman was egregiously murdered, even though there was a protection order in place, and he said, yeah, well, the cops, you know, it said they shall intervene, but that doesn't mean what everybody thinks it means. It means they may, or then again, they may not. And of course, you know, in our infinite wisdom, we realize that they really don't have a duty to put their life at risk for your benefit. Meaning, basically, if they see somebody murder you, stabbing you to death, you could look over and yell, help, 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 help. But they absolutely have no duty to put their life in harm's way, and that was exhibited in Florida when all the kids were being shot up during Democratic fucking bullshit, when the White House was occupied by Democrats, mind you, and the kids were being shot up, and the alleged officer hid underneath the stairwell of the high school. They tried to sue him, and they said, look, that guy had no duty to put his life in harm's way for your children. Fuck off, you vagrants, you peasants, you pukes who don't know the law and don't realize that you should carry a gun everywhere you go, because that's actually what makes a peaceful society, is a well-armed society. But because you guys don't know that, just keep pretending that we serve and protect the fuck out of you, because we serve and we definitely extort the shit out of you, but we do anything but serve and fucking protect you, all right? So that's all the reason that I'm showing this shit right here. Plus, my brother James, a great mentor of mine, has put a lot of work into this, and I've used this to spank a lot of the county clerks because they get nervous. For example, county clerks, 11-107, when you go in there and slap this on a fucking table after they've sat there and told you they're not going to do their job, they get really nervous because now they don't have plausible deniability anymore. And they call the lawyer up and, he showed me some paper. Yeah, well, you don't have to do anything, that guy says. Okay, here's my notice. here's my notice. I'm putting you on notice. You're causing me a harm. You're taking your income under false pretenses, and you are violating my unalienable rights. And here we go down for the shit show. Anyway, bonds, county, precinct, townships, officers, approval, filing, place, recording, county clerks. The official bonds of all counties, precincts, and township officers shall be approved by the county board, except the official bonds of the county commissioner or supervisors, which shall be approved by the county judge. All such bonds shall be filed and recorded in the office of the county clerk, except the bonds of the county clerk and members of the county board, which shall be filed and recorded in the office of the county judge. Now, again, this only applies to Nebraska, so don't get a harebrained idea that because I said this is exactly how it is in every state, because it is not. The official bond of the school district treasurer must be approved by the president of the secretary and filed in the office of the treasurer of the county. 11.110 bonds recording copies and fees. The officer with whom any official bond are required by law to be filed shall carefully record and preserve the same in their respective offices, and shall give certified copies thereof when required under the seal of their office. Shall keep a book. The county clerk shall keep a book in which shall be entered in alphabetical order. Now, again, the word shall doesn't mean must, and because of that, the codes, again, are written very vague and ambiguous to dissolve all liability and all that good bullshit. But if you're none the wiser to it and you want to go up there and whine and cry and say, look, clerk, it says right here, you shall do this. And she's going to go, yeah, I already talked to the lawyer. He told me to tell you to fuck off because you don't know how to read. You don't know how to read, so you can fuck off, Jack. I got nothing to worry about. That's what that lawyer's told me. So, but you can still hold them liable. Make no mistake about it. The county clerk or register of deeds may, in their infinite wisdom, if they so choose, refuse to accept and file any instrument failing to meet the requirements of this section, provided that if the county clerk or register of deeds determines that all signatures on the instrument are legible, he shall not refuse to file the instrument. Let me go back here again. Okay. 23, 13, 11, instrument signatures, illegible, refusal to file. The name of the names of each signature, blah, 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 blah. Okay, this is about names not being legible. What else did he highlight out of this? Oaths and affirmation. All courts have the power to administer oaths connected with any matter pending before them, either by any judge, justice, or clerk thereof, within their respective counties. Official records, proof of lack of record. Official records, certified copies. Duty of custodian to furnish. Fees. Every state, county, and political subdivision officer having the custody of a public record or writing is bound to give any person on demand a certified copy thereof on payment of legal fees therefor. Which is kind of a complete contradiction because, again, they can't tell you exactly what the fuck they are looking for because of what I explained at the beginning of this video, Title 31, along with a number of other things. So they really can't ask you for shit without violating the law. It is the duty of the clerk of each of the courts to file together and carefully preserve in his office all papers delivered to him for that purpose. So basically they're a custodian of record. You can let them know that they're keeping a record in error, and if that record causes you harm, they're 100% liable for failure to correct that record or adjust that record so it doesn't cause you any harm. The clerk of the court shall endorse upon every paper filed with him the day of filing it, and upon every order of the provisional remedy, and upon every undertaking given under the same, the day of its return to his office. This one was for the courts because they always want to charge you for copies, except where the action is filed electronically upon the initial filing of a civil action. There shall be presented to the clerk clear and legible duplicated copies of each pleading together with all exhibits in sufficient number to provide one copy for each adverse party. District Courts of Nebraska. D. Copies upon request. Parties shall immediately furnish to the clerk clear and legible copies of any pleading, order, judgment, exhibit, or any other matter of record in such numbers as necessary to enable the clerk to comply with the provisions of any statute or rule. And that was just something he put together there. Let's see what other cheat sheets he's got me. I had a really good one on money that he put together that was just darling. It was a stunning piece. Equity maximums, Libra code. That's always a fun one. Land patents. All right, I can't find any other cheat sheets I want to share with you guys. What was that one? Recording papers, cheat sheet, equity maximums. Let's see. Let's see if this pulls up anything. Maybe I deleted it. That would be a horrible thing there. All right. So let's get into the next subject matter here. Just kind of having fun poking around. Eventually, I'm going to do a nice dissertation. For those of you that aren't familiar with navigating the court very well, at least getting you set up for an appeal. Learning your objections, learning how to take exception to the bullshit they're doing, learning how to speak it into existence on the fly, off the cuff will really benefit you. Even if you don't know why you're objecting, if you happen to be subject to these courts and you can't seem to get turned loose, that's something that we're going to work on. And that comes out of the good old law library and the law Bible. And I have like 15 books that are each 78 pages long, and they're just like paint by numbers, how to do things in court. And I think it would be very beneficial for all of you guys. Teach you how to make demurs, teaches you how to do negative averments, confession and avoidance, objections, written objections, motions, all that stuff. If you're not learned enough to cut the ties from these bastards in real short order by challenging jurisdiction, subject matter, and territorial jurisdiction as well. Okay, now I know that I sent a good one out there. That was case dismissal. That's not what I'm looking for. Ah, there it is. Brilliant. Wunderbar. We've got it. All right. Now, let's talk about subject matter jurisdiction. Remember, subject matter can never be presumed, never be waived, and cannot be construed even by mutual consent of the parties. Subject matter jurisdiction is two-part: the statutory or common law authority for the court to hear the case and the appearance and testimony of the competent fact witness. In other words, sufficiency of pleadings. Even if the court judge has or appears to have subject matter jurisdiction can be lost. Major reasons why subject matter jurisdiction is lost. 1. Fraud upon the court in regards to Village of Willowbrook, 37-3, Appellate Level 3D 393, 1962. And 2. A judge does not follow statutory procedures. Armstrong versus OBUCINO 303 143. This case was held in 1921. 3. Unlawful activity of a judge or undisclosed conflict of interest. Code of Judicial Conduct. All right. 4. Violation of due process. Jones versus Zerps. 304 U.S. 458 58 S period CT period 1019. This case was had in 1938. Pure Oil Co. versus City of North Lake, 10-3 2D 241 245 140 N period E period 2D 289. This case was held in 1956. And Halliburg versus Goldblatt Bros, 363-3, 1936. If the court exceeds its statutory authority, Rosenthal versus Rosenthal, 278 F Superior Court, 794, SDNY, 1967. 6. Any act in violation of 11 U.S.C. 362A, the bankruptcy stay, in regards to Garcia, 109B, period, R, period, 335, N, period, D, period, Illinois, 1989. 7. Where no jurisdiction issue is presented to the court through proper pleadings, Legion versus Williams, 264, 3, APP, 3D, 701, 637, N, period, ED, E, period, 2D, 633, 1st District, 1994. 8. Where a complaint states no cognizable cause of action against that party, Charles versus Gore, 248, 3, Appellate Court, 3D, 441, 618, N, period, E, period, 2D, 554, 1st District, 1993. 9. Where any litigant was represented before a court by a person, law firm, that is prohibited by law to practice law in that jurisdiction. 10. When the judge is involved in a scheme or bribery, 11 Alman case, Bracey versus Warden, U.S. Supreme Court, number 96-6133, June 9th, 1997. Where a summons was not properly issued. 12. Where service of process was not made pursuant to statute and Supreme Court rules, Janovo versus Bacon, 632D, 245, 249, 218, N, period, E, period, 2D, 706, 708, 1955. 13. Where the statute is vague. Well, I've just showed you how all these statutes are vague and ambiguous, and they use pronouns like you, it, he, she, them, the, that, all those pronouns mean that it's vague and ambiguous. They're not being specific. And remember, the law is specific, okay? 14. When proper notice is not given to all parties by the movant, Wilson versus Moore, 13-3, Appellate Court, 3D, 632, 301, N, period, E, period, 2D, 339, 1st District, 1973. Where an order judgment is based on a void order judgment, Austin versus Smith, 312, F, period, 2D, 337, 343, 1962 was the year of the case, and English versus English, 72, 3, Appellate Court, 3D, 736, 393, N, period, E, period, 2D, 18, 1st District, 1979, or 16, where public policy is violated, Martin Tragana versus Roderick, 29, 3, Appellate Court, 3D, 553, 331, N, period, E, period, 2D, 100, 1st District, 1975. Summary of the law of void judgments. Before a court can proceed judicially, jurisdiction must be complete, consisting of two opposing parties, not their attorneys. Although attorneys can enter an appearance on behalf of the party, only the parties can testify, and until the plaintiff testifies, the court has no basis upon which to rule judicially, and the two halves of subject matter jurisdiction equal the statutory or common law authority. The action is brought under the theory of indemnity and the testimony of a competent fact witness regarding the injury, the cause of action. If there is a jurisdictional failing appearing on the face of the record, the matter is void, subject to vacation with damages, and can never be time barred. A question which naturally occurs: if I vacate a void judgment, can they just come back and try the case again? Answer: a new suit must be filed, and that can only be done if within the statute of limitation. Lack of jurisdiction cannot be corrected by any order non-pro-tunc. The only proper office of non-pro-tunc order is to correct a mistake in the record. It cannot be used to rewrite history. Ergo, Transamerica Inc. Co. versus South, 975 F. Period 2D 321 325-26. Seventh Circuit. The number of void judgments on the books in America's courthouses is so great, there is no practical way to estimate how many there are. If every void judgment was vacated with damages, it would represent the greatest shift in material wealth in the history of the world. Well, there's some good stuff about that. What else? I don't think I'm going to ramble about any of this stuff, although it's good information. Yeah, I'm going to leave the rest of that alone. Let's see. Bink. Supreme Court cases. And a lot of this stuff, guys, I post on my wall. Let's see here. I want to find something for you from the Supreme Court. No immunity. Oh, you guys don't care about immunity. Surely you don't care about that. But what I wanted to share with you, right here it is, ladies and gentlemen. If there's anything that you get from this damn video, I want you to write this shit down. If you have relied on prior decisions of the Supreme Court, you have a perfect defense for willfulness. Write it down. If you have relied on prior decisions of the Supreme Court, you have a perfect defense for willfulness. That is U.S. versus Bishop, U.S.V. Bishop, BISHOP, 412 U.S. 346. That one right there should always be toted around with you. All right, I'm going to let you guys go. I got other business to handle. I got other stuff to do. Thanks for joining me. Thanks for all your support. I'll be back later. We'll start talking about process, procedure, modes, jurisdictional issues, things like that. Help you guys out. Like I said, I'm not the end-all be-all. I don't have all the knowledge. I don't have all your answers, but maybe, just maybe, with a little proper guidance, you will be able to do well for yourself. Fight for yourself. Fight for your community. Fight for your friends. Fight for your family. Because after all, freedom is not free, ladies and gentlemen. So thanks for joining me. Thanks for all your support. Much love. And I'll be back with you later this evening to create some more videos for you guys that hopefully will benefit you.